In the past few episodes, we started a series on intellectual property, where we discussed how one's creative ideas, such as books, architecture, films, and all other original ideas can be protected by law through copyright, which does not require registration with any regulatory authority, as long as there is proof that the creation is originally yours. In a follow-up episode, we spoke about industrial property with Timothy Mwalusi as being a term used to refer to rights which are given as an exclusive monopoly on exploitation and is obtained through registration. In Botswana, industrial property rights are protected through the Industrial Property Act, which include, amongst others, patents. Timothy explained that patents are grants given by the state where an office like SIPA grants rights to an inventor who has developed a technical solution to solve a problem in a particular industry. The inventor can then patent their creation, where this patent can be protected for a period of 20 years after being registered. This evening, we end our three-part series with a look at the rights and responsibilities of intellectual property holders. For this discussion, we have engaged the expertise of Copyright Administrator at the Companies and Intellectual Property Authority, Yitzing Munyazi, and her colleague, Registrar Industrial Property, Timothy Mwalusi. We speak to them first about what some of the most common intellectual property infringements in Botswana are.
The common ones generally is where people try to copy trademarks that are well known or brands that are well known. A few years back and even currently, people would then, for example, I'll use an example of Nike. Somebody would then want to develop a product and call it Mike. So they develop a similar product. And then they call it Mike with a view to ride on the goodwill of the well-known brand, because they know customers are loyal to that particular brand. So in that case, most of the infringements that we'll see is where people now try to imitate the existing or well-known brands with the view to ride on their goodwill to make money out of it. Therefore, in that case, it is the owners of the brands who have responsibility to ensure that if there's any infringement, they can take action against the infringer and stop them from using their trademark or even a similar trademark to confuse the market.
Traditionally, or the infringement that we are used to as Botswana is the ones for where people sell fake CDs. You pass by a service station, you find somebody selling a CD. But what we are now seeing in the advent of technological development is that there's a lot of infringement that takes place in the digital space. You sit in front of your computer, you download a movie, you share it with your friends and all the like. If we are to be strictly speaking, this is a violation of copyright. So a lot of infringement nowadays is taking place in the digital environment, and it is very difficult for the compliance officers, including SIPA, to actually monitor.
From a rights holder point of view, what options are there for rights holders when they realize that somebody has been using that intellectual property illegally?
Definitely it impacts them by stealing away an opportunity that they could have had to actually make money out of it. Because if you are supposed to, say, go to a cinema to go and watch a movie, you are going to be paying for that movie, and somehow ultimately the rights holder get to benefit. But if you watch that movie on your computer, it means that you are not going to pay anything, so the right holder doesn't get to benefit anything. So the possibilities that the rights holders have is that the law says it's an exclusive right. So if they get to find that you're actually infringing their rights, they have a right to take you to court. So that is where it is. But we have to acknowledge that it is not easy because, like I said earlier, of the intangible nature of these rights. You'll be doing it maybe in your house and they don't know that you're in your house infringing your rights. But the key thing is that if you are found out, you are liable for a lawsuit, and our law is very clear. You can be put to jail for that. You can also be charged maybe up to a maximum of 20,000 pula.
Can there be instances where somebody else's intellectual property can be used legally?
There is intellectual property, like I said, it's property. The same way that you can allow me to wear your jacket is the same way that I can engage with you and say, I like your song, I want to use it in my advert.
There are ways in which you can use it legally. So the legal route is to actually seek for a license from the owner of the right. So in terms of the law, like any property, you can license it to somebody and then request for a license from the brand owner or the IP owner, and they license it to you to pay royalties. Or you can actually seek to buy it outright. And in terms of the law, we call it an assignment of rights, where now you transfer the ownership of your property to the other person who's looking for it. So when you now do such transactions, you as the one who's seeking for a license, you must understand the value of that so that you can be able to negotiate the rate at which the royalties that you may pay, or understand the value with a view that what you pay for actually is worth it.
We're currently living in the digital age where a lot of information is shared through various internet media. Say, for example, your Twitter, Instagram, Facebook, TikTok these days, and a lot of them. So what sort of challenges can you speak to that you've realized in enforced space?
There's no easy answer or solution to it because, with the digital platforms, infringement can happen in far away from where you are. It happens in multiple jurisdictions. It happens in different countries. I can have a famous brand doing very well in Botswana, and on that platform, somebody in another country uses it. So therefore, those are the challenges that we are facing these days. And the only way then is to choose where you want to go in terms of how your strategy, in terms of how you want to be able to deal with enforcement in that platform. So if, for example, your market is another country which you have been trading on in that particular market, then what you need to do then is to ensure that in that country your brand is protected, and therefore you can then seek for to enforce your rights in that particular country. So when we talked earlier about the ability to register in multiple countries, that gives you then the advantage that which of those countries that you have protected, when there's an infringement that you see emanating from a particular country, then you can approach the courts in those countries and seek for remedies in that country.